Hello friends, welcome you all to my YouTube channel Discourse Online Politics. We are discussing about the question paper of UP APO prelims of 2002. In the previous series of this, we had discussed the questions from the Indian Evidence Act. And now in today's video, we are going to cover rest of the questions which had been asked in the UP APO prelims examination of 2002. So before going to discuss the rest of the questions from this examination of 2002 of UPAPO, I request to all of you, please like this video and subscribe this channel so that you can get this kind of the videos in future as well, so that you can update yourself, you can get the time for revision as well. And with this hope, I'm going to discuss the rest of the question here from the UPAPO examination of 2002. If you just go to the previous video which I had uploaded on my YouTube channel, you can see that we had discussed these questions from the law, and all the questions which I had discussed, they were questions from the Indian Evidence Act. So we had discussed all these questions. So just go to the previous video which I had uploaded on my YouTube channel so that you can get the answer of these questions, and you can go to these questions while having any kind of journey. You can see all these videos, you can prepare all these things while you are in journey, or if you are doing some work, then you can meanwhile you can go to this video and you can go for the revision as well. So this is a kind of the video which will be very much helpful. You need not to carry much for revision of this previous year question paper. You need to just have a mobile phone and you can go through. So this is a kind of the way it will save you time and it will help you to for more revision as well. Now if you see, in the previous video we had covered till the question number 75. Now here we are going to start from question number 76 onwards, and the question number 76 is saying this: in a cognizable offense, a police officer can, and the options which are given, cannot arrest an accused without warrant, and the another option which is here, that is can arrest without warrant. So the right answer is this, that the police officer can arrest any person if he has committed a cognizable offense without warrant. So this is the right answer. We are not going to discuss much options here for this question. The next question: who among us the following is not entitled for maintenance under section 125 of the CRPC? Now the options which are given here, the first one is illegitimate minor child, the second is uterine brother, the third is father, and the fourth is divorced wife. So the right answer is uterine brother. Uterine brother means whose father are different but mother is the same. So the uterine brother is not entitled to get the maintenance under section 125 of the CRPC. The next question which had been asked, the main characteristics of the CRPC is the empowerment of executive magistrate with judicial power, the separation of the legislature from the executive, the separation of the judiciary from the executive, and the fourth is the separation of the revenue work from the executive. The right answer is, it is the separation of the judiciary from the executive. So this is the right answer. The next question which had been asked, who can commute the sentence of imprisonment for life under the CRPC? The options which are given here, the appropriate government, the President of India, the Governor of the state, and the central government. And the right answer is the appropriate government. Another question which had been asked from CRPC, it is the power of the Supreme Court to transfer cases and appeals from one high court to another high court can be exercised on an application by which one of the following. And the options which are given here, the Registrar of the concerned High Court, Attorney General of India, Chairperson of the Bar Council of India, and the last option is Solicitor General of India. The right answer is Attorney General of India. So this is the question answer, that is the Attorney General of India. The next question which is here, and that is from CRPC. It is the same. It is the same from CRPC. A sentence of imprisonment for a term of 10 years may be passed by which one of the following? And the options which are given here, the court of a magistrate of the first class, the court of a chief judicial magistrate, the third option is an assistant session judge, and the court of a chief metropolitan magistrate. The right answer is here, which is right answer. The right answer is here, that is the session judge, and now the answer is here, that is the an assistant session judge. The next question, it is also from CRPC. A private person may arrest any person who A, the option A is reported to be criminal. B, in his presence commits a non-cognizable offense. In his presence committed a cognizable offense. In his presence committed a cognizable and non-billable offense. The right answer is D. In his presence he commits a cognizable and non-billable offense. Then in that case, a private person can arrest the person who has committed a cognizable and non-billable offense. Section 43, clause 1 of the CRPC gives the answer to this question. The next question from CRPC, which had been asked in the UPAPO 2002, the question is here: under which section of the CRPC a proclamation for person absconding may be issued? The options which are given: section 83, section 82, section 81, and section 80. The right answer is section 82. So under CRPC section 82, a proclamation for person absconding may be issued. The another question which is also from the CRPC, that is, which section of the CRPC provide for trial before a court of session? This is another question, and the options which are given here: section 225 to 237, section 228 to section 243, section 251 to section 259, section 260 to section 265. And the right answer which is here, that is the A, section 225 to section 237. So you friends, you can see that the question which are coming from the CRPC, they are coming from directly from the sections as well, and sometimes they are asking about the particular section as well. So you need to prepare very well about the bare act of the CRPC. The other question which had been asked in the UPAPO 2002, that is, which section of the code of criminal procedure provides for prosecution for offences against marriage? So that means under which section of the CRPC there is a provision for prosecution for offences against marriage, and the right answer is section 198. So this is the right answer here of the CRPC. Another question which had been asked in the UPAPO 2002 from CRPC: when an accused does not have sufficient means to engage pleader, the session court may assign a pleader for his defense at the expense of the state. It is ensured by which section of the CRPC? So the options which are given here, that is section 301, section 304, section 306, and section 305. The right answer is section 304 of the CRPC, through which the states will ensure that if any person who is not able to hire any advocate, then in that case, by virtue of section 304, the state will provide a a defense lawyer. The another question which is here, that which has been asked: who among the following is not empowered to tender pardon to accomplice under section 306 of the CRPC? And the option which are given here, that is the and the option which are given here, that is the metropolitan magistrate, magistrate of second class, chief judicial magistrate, magistrate of first class, and the right answer is magistrate of second class. So this is the provision which has been given under the section 306 of the CRPC. The another question which had been asked: which section of the CRPC provides that no statement made by any person to a police officer in the course of an investigation shall, if reduced to writing, be signed by the person making it? And the options which are given here: section 164, section 163, section 162, and section 161. My dear friends, these sections are very much important, and this type of questions are very popular in the MCQ. So you need to go to all these sections, and for this question, the correct answer is here. That is the section 162. The next question which had been asked in the UPAPO 2002, and that was the question of find out incorrect answer. The first information report, that means FIR, report about cognizable offense, information given to the police officer, information first in point of time, and it must always be given in writing. So what you find that this kind of the things which are given here. So it is report about cognizable offense. So what you can see, this kind of the right answer is section 154's answer is, that is the report about cognizable offense. The another question is point out incorrect answer. Under section 125 clause 4 of CRPC, the wife will not be entitled to maintenance allowance if she is living in adultery, she refuses to live with her husband without sufficient reason, she is living separately by mutual consent, she embraces some other religion. So in case if she embraces other religion, even though she will be entitled to get the maintenance. However, on the above grounds on or other options, on that basis, the wife is disentitled. So if she is living in adultery, if she refuses to live with her husband, if she is living separately by mutual consent, then in that case, she is not entitled to get the maintenance. So that is this question which had been asked in the UPAPO 2002. The next question which had been asked in the UPAPO: which section of the code of which section of the CRPC authorizes a private person in arrest any person committing cognizable offense? So the options which are given here: section 44, section 42, section 43, and section 45. And the right answer of this question is section 43. Point out incorrect answer. The other question is point out incorrect answer. The requisites of a valid warrant are: the option A, it shall be in writing; option B, it shall be signed by presiding officer of the court; option C, it shall bear the seal of the court; option D, it must state the name of the accused, but address is not necessary. So this is the incorrect answer. Always there must be name of the accused as well as the address of the accused person. So this is the right answer. The next question which had been asked in the UPAPO 2002, that an order of life imprisonment may be passed by Chief Judicial Magistrate, Session Judge, Metropolitan Magistrate, any magistrate of the first class, and the right answer is Session Judge. The another question which had been asked here, Which of the following statements are correct? The options which are given here: investigation is made by a police officer. The object of police investigation is to collect evidence. Investigation is a judicial proceeding. Investigation is not a judicial proceeding. So based on these statements, we need to give the answer on the codes. So now let's see what are the codes which are given here. So you can see 1, 2, 3, 1, 2, 4. Yes, of course, investigation is not a judicial proceeding. So this statement, investigation is a judicial proceeding, is incorrect. Now, the next question which had been asked: object of investigation is to punish the accused, acquit the accused, to collect the evidence, and the last option which is given here, that is the to convict the accused. So the right answer is to collect the evidence. This is the purpose of having the investigation. The other question which had been asked: under which section of CRPC a session judge exercise power of appeal? So the options which are given here: section 373, section 376, section 397, section 398. The right answer is section 373. The another question which had been asked: under which section of the CRPC an accused person can himself be a competent witness? So the options which are given here: section 311, section 313, section 315, and the section 319. And the right answer is the witness, an accused person can be a competent witness under section 315. The another question which is here, that is an offence punishable with imprisonment for a term exceeding 2 years relate to. So, and the options which are given here: summon cases, warrant cases, either of the above two, neither of the above. So the right answer of this question is here, that is the warrant case. So any offence which is punishable more than 2 years, that kind of the offences would be called as a warrant case. The other question which had been asked here, that is a chief judicial magistrate may pass sentence of imprisonment not exceeding 7 years, sentence for life imprisonment, sentence of imprisonment exceeding 7 years, and last option is death sentence. And the right answer is here, the sentence of imprisonment exceeding 7 years. So that is the way you can see the options are given here. So another option is sentence of imprisonment not exceeding 7 years. So the right answer is that the chief judicial magistrate may pass a sentence that may be. So this was the right answer. Sentence of imprisonment exceeding 7 years. The other question which had been asked in the UPAPO 2000 prelims: a conditional order for removal of public nuisance under section 133 of the CRPC may be passed by the options which are given here: district magistrate, the sub-divisional magistrate, executive magistrate especially empowered, and any of the above magistrates. So this section 133 talks about the executive magistrate. So all the magistrates like DM or SGM or any executive magistrate, they are empowered. So the right answer is option D here. The another question which had been asked in the UPAPO 2002, that is, A intensely fired a shot from his pistol at B, but it hit C and C died. The offence committed by A is. So this is a question from the Indian Penal Code here. So now the options which are given here: attempt to murder, culpable homicide, The third option is murder under section 300. The fourth option is, that is the murder under section 301 of the IPC. So therefore what you see, the right answer of this question is here, murder under section 301. So he will be liable under section 301 of the IPC. So this was the question which had been asked in the UPAPO prelims of 2002, and the question was from the IPC. The next question which is here, that is A makes a false entry in the electronic record for the purpose of using it as a corroborative evidence in the trial court. So A has option A, fabricated false evidence, not fabricated false evidence, committed forgery, and the last option is none of the above. So the answer which is given here, that the A has made a fabricated false evidence. Okay. The another question which had been asked in the UPAPO prelims of 2002, a workman throws snow from a proof giving proper warning. A passerby is killed. The workman is, the options which are given here, guilty of murder, guilty of culpable homicide not amounting to murder, guilty of causing death by negligence, and not guilty since death was accidental. And the right answer to this question is here, that is the guilty of murder. So he will be uh, guilty of murder here. The another question which had been asked in the UPAPO 2002, that is which section of the Indian Penal Code defines seditions? And the options which are given here, section 100, 122, section 123, section 124, and section 124A. And the right answer is section 124A here. The another question which had been asked in the UPAPO prelims 2002, that is, A puts his hand in the pocket of B for stealing money, but the pocket was empty. A is guilty of, the options which are given here, theft, attempt to commit theft, mischief, and no offense. And the right answer is attempt to commit theft. Why this is so? Because he has attempted to commit the theft. However, there was nothing in the pocket of B. The next question which had been asked in the UPAPO 2002, which one of the following sections of the Indian Penal Code deals with the vicarious liability? And the options which are given here, section 120A, section 121, section 154, and section 159. And the right answer of this question is section 154 of the Indian Penal Code. The other question which had been asked, it is based on the assertion and reason. So what is the assertion? Nothing is an offense which is done in the exercise of the right of private defense. The reason is, where the aid of the society cannot be obtained, individual may do everything necessary to protect himself. So of course, this is based on the necessity. And yes, so the right answer is both A and R correct. They are true, and R is the correct explanation of A, because it may not be possible that he can take the help of any individual, other people. Therefore, the right of private defense has been given here. The another question which had been asked in the UPAPO 2002 prelims, the ingredients of section 149 of the Indian Penal Code are, the options which are given here, knowledge of the probability of the commission of the offense. The another options, that is common intention. The third option which has been given here, that is the unlawful objects stated in section 141 of the IPC. And the last option which has been given here, active participation in the commission of a crime. And the options which are given here, the right answer is here the 1 and 3. That means knowledge of the probability of the commission of the offense, and the third one is unlawful object stated in section 141 of the IPC. The another question, that is question number 109, it is also based on the assertion and reason. The assertion is here: homicide is the killing of a human being by a human being. So this is the a definition, you can say, has been given about the homicide here. And what is the reason here? Homicide is always unlawful. Now the quotes which are given here, both A and R true, and R is the correct explanation of A. Both A and R true, but R is not the correct explanation. This is the right answer, because there may be some situations where homicide has been done, but it was in the private defense. So in that case, it would not be unlawful. The other question which had been asked, which one of the following is not a correct ingredient of the offense of theft? So which one of the following is not correct ingredient of the offense of theft? The options which are given here: dishonest intention of take property, property must be movable, and the other option which is given here, property must be taken without the consent of the person in whose possession it is, property must be taken without the consent of the owner of the property. So the right answer of this question is here, that is the last one. So property must be taken without consent of the owner of the property is not the ingredient of the theft here. There may be a case that you had taken a property, someone has taken the property from a person who is not the owner of the property. So it is not in all the cases that the property must be taken from the owner only. The other question which had been asked in the UPAPO 2002 prelims examination, that is, which one is not an essential ingredient of a crime? The options which are given: motive, evil intent, human being, and D, that is the act. So this, which one of the is not an essential ingredient of a crime? And the right answer is, it is human being. So this is the way you can find here. It is about the crime. Okay. Therefore, it is not necessary that in all the cases, there must be a human being. Now the another question which is here, that is about the common intention. Common intention means similar intention, same intention, then the sharing of intention by all persons, common plan. So the right answer is, there must be a sharing of intention by all persons. So this is the right answer. The other question which had been asked in the UPAPO prelims of 2002, that is, the sexual intercourse by a man with a woman, even with her consent, is a rape if she is below the age of, the options which are given here: 17 years, 16 years, 19 years, and the 18 years. The right answer is, that is the 18 years. Which one of the following is not a punishment under section 53 of the Indian Penal Code? So which is not a punishment under section 53 of the IPC? So that is the options which are given here: fine, transportation, forfeiture of property, and death. And the right answer is transportation. This is not a punishment under section 53 of the IPC. The another question which had been asked in the UPAPO prelims 2002, in which of the following case the right of private defense of body does not extend to causing of death? And the options which are given here, that is the assault with the intention of committing kidnapping, the option B, assault with the intention of gratifying unnatural lust, the another option which has been given, wrongful restraint. The next option is that is assault with the intention of committing abduction. So this is the right answer, that is the wrongful restraint. So therefore what you can see in this situation, the private defense of body does not extend to cause the death. The another question which had been asked here, that is the question, that is the unlawful assembly has been defined in the IPC under section, the options which are given here, the options are section 141, section 146, section 149, and answer and the section 159. And the right answer, you all know that because it is a very popular question, section 141. The other question, which one of the following statement is not correct? And the options which are given here, abatement of an abatement is not an offense. My dear friends, we have to give the answers about the statement which is not correct. Okay, so we need to very careful about this, because sometimes what happens, while answering the questions in the examination, we could not understand that what kind of the statement has to be look into, whether it is about correct or it is about the incorrect. Okay, so we need to careful about this. So the options which are given here, abatement of an abatement is not an offense. Abatement of illegal omission may be an offense. To constitute the offense of abatement, the effect requisite to constitute the offense need not be caused. The person abated need not be capable by law of committing an offense. So my dear friends, that abatement of an abatement is also an offense. So this is the right answer, but the statement is here written incorrect. So this is the incorrect statement. The another question which had been asked in the UPAPO prelims of 2002, that is, attempt to commit robbery is punishable under which section of the IPC? The options which are given here, section 392 of the IPC, section 393 of the IPC, section 390 of the IPC, and section 394 of the IPC. The right answer is here, section 393 of the IPC. The next question which had been asked in the UPAPO prelims of 2002, that is, which one of the following is not an essential ingredient of the offense of kidnapping under the IPC? The options which are given here, a minor child. The second option is intention of the accused. The third is without the consent of lawful guardian. And the fourth option is out of the keeping of the lawful guardian. So the right answer is here, intention of the accused. It is not an essential ingredient for the kidnapping under the IPC. Another question which had been asked in the UPAPO prelims of 2002, that is, making a preparation to commit dacoity is punishable in the IPC under section 393, section 395, section 398, and section 399. So the right answer for making preparation to commit dacoity is punishable under section 399. The next question is match list first and list 2 and select correct answer using the codes given below the list. And let's see what are the list has been given here. So if you see the list which are given here, list 1 and list 2. In the list 1, the section is given section 463, section 445, section 441, section 440, 441, section 503. And on the other side, list 2 talks about the offenses like criminal trespass, forgery, criminal intimidations, and house breaking. And if you look to this, the right answer of this question is here, option A. Why this is so? Because section 463 talks about the forgery, section 445 talks about the section 440 talks about the house breaking. Section 441 talks about the criminal trespass, and section 503 talks about the criminal intimidation. So therefore, what you see, the right option is A. Okay. The another question which had been asked in the UPAPO prelims of 2002, the case of Gyan Kaur versus State of Punjab is related to whether murder, culpable homicide, abatement of suicide, attempt to commit suicide. And the right answer is attempt to commit suicide here. Okay. The next question which had been asked, in which of the following cases the Supreme Court declared section 303 of the IPC code as unconstitutional. Okay, so the options which are given here: Sher Singh versus State of Punjab, the option B Mithu versus State of Punjab, the option C Bachchan Singh versus State of Punjab, the last option is Triveni Bain versus State of Gujarat. The right answer is here Mithu versus State of Punjab. In this case, the Supreme Court has declared Section 303 of the IPC as unconstitutional. The another question which had been asked: A removes B's book from his house without his consent with the intention to return it to him if he as a friend rewards him for the return. A is liable. So a person A who has taken a book from B and with intention that once his friend will search for that book and then he will give that book, and in return to that he will give a reward to B to A. So therefore what you say, this kind of the things are given. So whether A is liable for theft, attempt to theft, or criminal breach of trust, attempt to criminal breach of trust, because you can see the 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 things which the A has done, it was with an intention to get the reward from the B. Therefore there was a dishonest intention, and therefore A would be liable for the theft. Okay, the another question which had been asked: A incites B to base C. Subsequently, A reaches the place where V is beating C. So A incites B to beat C. Subsequently, A reaches to the place where B is beating C. A is liable under this section. A is liable under section 34, section 109, section 114, and section 115. So he will be liable under section 114 of the IPC. The other question which had been asked: A cheats by pretending to be B, a person who is deceased. A is liable to be punished under which section of the IPC? And the options which are given here: section 4 and 20 of the IPC, section 419 of the IPC, section 418 of the IPC, section 417 of the IPC, and the right answer is here section 419 of the IPC. The another question which had been asked: in exercise of the right of private defense of property, death cannot be caused in the case of robbery, housebreaking by night, mischief by a fire in dwelling house, and the theft. So the right answer is theft. In the course of private defense, the death cannot be caused in the case of theft is happening. The another question is based on the assertion and reason. The assertion is here like this: a boy aged 9 years intentionally kills B, A is liable to be convicted. The reason which has been given: a child up to the age of 12 years is immune from criminal liability. Okay, so now the options which are given here, both A and R true, and R is the correct explanation of A. The another option is both A and R true, but R is not the correct explanation of A. A is true, but R is false. This is the right answer. Why this is so? Because a boy who is above the 7 years and up to the age of 12 years, he can get the immunity from the criminal liability, but he has to prove that he was not able to understand the nature of the act. So therefore, the option is C is correct here. The next question is here: in a dark night, A and B were fighting. B's wife, keeping her child on her shoulder, reached there for separating them. In the meantime, A's fist fell on the back of the child and the child died. A is liable for what kind of the offenses here? Hurt, grievous hurt, culpable homicide, or murder. So A is going to liable for the grievous hurt here. The other question: in which of the following offenses mens rea is not an essential ingredient? The options which are given here, that is the murder, theft, robbery, and the bigamy. So mens rea in which case is not required. That is the option which is there here. That is the bigamy. So for bigamy, there is need not to have a mens area. The other question which had been asked, A beats his wife, she fell down and became unconscious. Believing her to be dead and to save himself from being arrested for murder, A hanged her in the fan with rope. Post-mortem report disclosed her death after hanging. A is liable for what? No offense, murder, culpable homicide, grievous hurt. So in this case, A will be liable for culpable homicide because he was under the impression that she is dead. However, she was not dead. The death was caused because of the hanging. Okay. The other question which was asked in the UPAPO prelims of 2002, the word good faith is defined in the IPC in section 44, section 51, section 52, and section 52A. And the right answer is section 52. The other question which had been asked in the UPAPO prelims is cutting the wood with an axe at a place where children are playing. The axe flies off and kills a nearby child. A is liable for what? No offense, murder, culpable homicide, causing death by negligence. So here the A is liable for the offenses causing the death by the negligence. The other question which had been asked, insanity is lack of free will, incapacity produced due to drunkenness, incapable of knowing the nature of the act committed, and the other option is disease mind. And the right answer is insanity means the person is incapable of knowing the nature of the act committed. So a person who is not able to understand about the nature of the action, then in that case, that person is being called as a insane, and therefore this is the definition of the insanity. The other question which had been asked in the UPAPO prelims of 2002, that is the A finds a purse with money not knowing to whom it belongs. He afterwards discovers that it belongs to B and appropriates to his own use. A is guilty of the options which are given here, that is the theft, then criminal misappropriation, criminal breach of trust, and cheating. And the right answer is criminal misappropriation. So if someone finds a purse and he has used that purse for himself, then in that case a person is liable for criminal misappropriation. The other question which had been asked in the UPAPO prelims, that is the which one of the following sections of the Police Act of 1861 has not been repealed. So now this is the question which had been asked from the Indian Police Act. So you can see the Police Act is also going to be asked here in the UPAPO prelims here. And the right answer of this question is here, that is the section 44. My dear friends, you all know that most of the students, they are very much used to uh, know of the practice of CRPC, IPC, and Indian Evidence Act. They are not very much aware about the Police Act of 1861. Therefore, you need to be very careful because these questions are going to make a difference. In the most of the cases, the students are doing well in the questions of the IPC, CRPC, and then the question of the Indian Evidence Act. But in case of the questions from the Police Act, they are not doing well. So please be careful about this. The other question is, what is the date of enforcement of the Police UP Amendment Act 2001? And the options which are given here, that is the 15th August 2001, 26th January 2001. Then another option is 10th August 2001, and the last option is 14th March of 2001. The right answer is 10th August 2001. The next question is here from the Police Act. Which paragraphs of the UP Police regulation deals with the absconding offences? Now, the options which are given here, that is section 196 to section 214, section 215 to section 222, section 190 to section 195, section 223 to section 276. And the right answer of this question is section 215 to section 215 to section 215 to 222. Now another question which had been asked from the Police Act of 1861, that is, who is the head of the criminal administration in a district? The options which are given here: superintendent of police, district magistrate, additional district magistrate, and the last option is none of the above. The right answer of this is here, that is the district magistrate. So district magistrate is the head of the criminal administration here. The another question which had been asked from the UP Police Act of 1861, a police constable compels a person to remain in police station on false case of theft and allowing him to go after receiving money from him. He is liable for what kind of the offences here? And the options which are given here, that is forgery, cheating, extortion, and the last option is, that is the wrongful confinement. And the right answer is cheating here. The other question from the UP Police Act, that is, under which section of the Police Act additional police force is provided in a district on certain conditions? The options which are given here: section 13, section 16, and then the third option is section 14, and the last option is section 15. And the right answer of this question is section 15 of the Police Act of 1861. So this was the question from the UP Police Act of 1861. The next question of this UPAPO prelims of 2002 is of UP Police Act 1861 from the is here. The next question is here from UPAPO prelims of 2002 from the UP Police Act is here. That is, under which section of the Police Act the state government is empowered to make rules and regulations governing the service conditions of members of police force? And the options which are given here: section 2, section 3, section 4, and the last option which has been given, that is the none of the above. And the right answer is here, that is the section 2. So under section 2, the state government is empowered to make rules and regulations governing the service condition of members of police force. Which section of the Police Act deals with the duties of police officers? Now the options which are given here: section 21, section 22, section 23, and the last option is here section 24. And the right answer of this question is here section 23. Section 23 of the Police Act deals with the duties of the police officers. The another question which had been asked, and that is the question is, which one of the following sections of the Police Act contains provision relating to general diary? So which provision of the Police Act deals with the general diary? It is very important question, my dear friends. So you need to remember this question. Okay, oftenly this kind of question are coming in the UPAPO prelims. So the options which are given here, that is section 43, section 44, section 45, section 46. And the right answer of this question is here section 44. The another question which had been asked in the UPAPO prelims of 2002, that is the regulation of public assemblies and processions and licensing of the same is provided in the Police Act 1861. Under which section? So the options which are given here: section 25, section 28, section 30, and section 32. And the right answer is here section 30. So section 30 of the UP Police Act of 1861, it talks about the regulation of public assemblies and processions and licensing of the same. The other question which had been asked in the UPAPO prelims, that is the under the UP police regulation, a village chowkidar is responsible to the the option A is here district superintendent of police, superintendent of police ruler. C option is village pradhan, and the last option is here, that is the district magistrate. So that person who is a village chowkidar, he is responsible to the district superintendent of police. The other question which had been asked, the power of the district superintendent of police to regulate the volume of music on the roads on the occasions of festivals is provided under clause 4 of section 15A of the Police Act. The another option which has been given, that is the clause 2 of section 27 of the Police Act. The third option which had been given here, that is the clause 4 of section 30 of the Police Act. The fourth option is here, clause 3 of the section 16 of the Police Act. And the right answer is clause 4 of the section 30 of the Police Act here. Okay. The next question which had been asked in the UPAPO prelims of the 2002, that is under section 25 of the Police Act 1861, the charge of unclaimed property is to be taken by the options which are given here, that is deputy superintendent of police, superintendent of police, district magistrate, and the last option which has been given, every police officer. So for the property which are unclaimed, it can be taken by every police officer. So this is the right answer. The second last question of the UPAPO prelims of 2002 is this question. The statutory powers of the Inspector General of Police under Section 7 of the Police Act 1861 is subject to Article 32 of the Constitution of India, Article 226 of the Constitution of India, Article 311 of the Constitution of India, and the last option is here, Article 309 of the Constitution of India. So he would be subject to this Article 311 of the Constitution of India. Why this is so? Because Article 311 talks about the service conditions. Okay, so therefore he would be liable for this under Article 311 of the Constitution of India. The last question which had been asked in the UPAPO prelims of 2002, and this is the last question, and it is also a question from the Police Act of 1861. The last question was this: special police officer under the Police Act 1861 can be appointed by the option A magistrate suo motu, the option B, the Inspector General of Police, option C, the Senior Superintendent of Police, option D, a magistrate on an application by an Inspector of Police. So the answer of this question is here, a magistrate on an application by an Inspector of Police. So section 17 of the Police Act of 1861 answers to this question here. So my dear friends, this was all about the solved, you can say that all about the questions from the UPAPO prelims, and I hope that this video will help you for revision, because you are having a short time. So whenever you are not at home, whenever you are not in your study room, whenever you are not in your lodge, whenever you are not in a hostel and you are on the way, then you can use this video to for the revision of the papers, because you all know that almost 40 to 50% questions are coming from the previous year question papers. So this video will help you definitely for revision. So whenever you are traveling, whenever you are somewhere else and you don't have any papers, books with you, then you can use this video for your revision. I hope that you had liked, and please subscribe this channel and like this video, so that we can prepare more videos in future for the revision and for other judicial examinations and the APO examinations. So thank you to everyone for watching this video. I hope that you had liked this one. So with this note, I am ending this video. Thank you to everyone.